We'll now start on our last section of negligence. This relates to defenses. The first defense to negligence is the allegation that the plaintiff caused or contributed to the cause of her own injuries. This defense is treated differently in different jurisdictions, and I'll tell you how. The traditional common law rule was contributory negligence, and it went like this. If the plaintiff contributed to the cause of her own injuries, she's barred from recovery, i.e., she gets nothing. This traditional rule was modified many years ago in some states, including California, which decided that the rule was too draconian and said instead, why don't we look overall at the entire event and figure out which party was responsible for which percentage of the harm, and we will then simply deduct the amount in which a plaintiff, if the plaintiff was negligent in causing her own injuries, will deduct that portion attributable to her own negligence from any recovery she gets against a defendant. And that rule is called comparative negligence. So it's the same allegation. In other words, the plaintiff caused or contributed to the cause of her own injuries, but it's treated differently in different jurisdictions. In a contributory negligence state, it means that the plaintiff will get nothing. In a comparative negligence state, it means that there will be a deduction in the amount of the plaintiff's own negligence. Incidentally, I've had students in the past say, well, I choose contributory negligence. You don't get to choose anything. I don't get to choose anything. It's up to the jurisdiction in which the negligence occurred. Do you have to know both rules? For instance, if you're in California, which is a comparative negligence state, why do you have to know about contributory negligence? Well, you need to know because as a business person, you may well be doing business in other states or traveling through other states. So in terms of, if you think about a good business person being able to establish liability risks, realize that those risks are going to be different among different states that have different rules. And this is the kind of risk that you would typically want to insure yourself against. Incidentally, in all jurisdictions, contributory or comparative negligence, if there are multiple defendants, a court will divide up the negligence among those defendants who are found to have been negligent. So, for example, let's say there's 4 defendants, all of whom have been found negligent. They'll decide, taking 100%, what percentage is the fault of each of those 4 defendants. Here's our first example, Markarian versus Young. Suppose that Anna Markarian was driving at 50 miles an hour on a street where the speed limit was 35 miles per hour. Jason Young made a left turn on a yellow light and the 2 drivers collided. In Markarian versus Young, what's the result? Well, suppose a jury found that Markarian was 20% at fault in causing her own injuries, while Young was 80% at fault in causing the injuries. If Markarian's total damages were $10,000, what result would there be in a contributory negligence state? Well, Markarian was 20% at fault in causing her own injuries, so she's barred from recovery. She'll get 0. What result in a comparative negligence state? In a comparative negligence state, a court would say Markarian was 20% at fault in causing her own injuries. Her total damages are $10,000. Therefore, we're going to deduct 20% from $10,000. So Young owes Markarian $8,000. Now, suppose that Young cross-complained against Markarian, and that would be called Young versus Markarian, and Young's total damages are $1 million. In Young versus Markarian, what result would we get in a contributory negligence state? Well, again, Young was partially at fault in causing his own injuries. He'll get nothing from Markarian. What if they are in a comparative negligence state? Okay, same idea. There's $1 million of damages. Markarian was 20% at fault in causing those. Markarian owes Young $200,000. Now note that although Markarian had a minority of responsibility for the accident, 20%, she ends up paying Young much more than Young owes Markarian. This is a function of the fact that their damage amounts were so different, but it's also a reminder of you as a business person to manage your risk. Realize that you or your employees, even if they're found liable only for a small percentage of the fault, it may result in a very large liability risk to you or your company. Okay, here's another sample question. Caroline versus John. Same idea. This is what it might look like on an exam. Caroline was rear-ended while driving. A jury found her to be 10% at fault in causing the accident. Caroline's damages are $100,000. In a contributory negligence state, how much would she recover? Contributory negligence, she's 10% at fault in causing her own injuries. Don't overthink it. The answer is D. She'll get nothing. Okay, the second big defense to negligence is called assumption of the risk. This has two parts. First, the idea that the plaintiff knew, or they should reasonably have known, that there was a risk. And secondly, that they voluntarily chose to take that risk. If you can show both things, then the defendant would have the defense of assumption of the risk. Suppose that you are foolish enough to get in the car with your friend who's a drunk driver and you let your friend drive. Were you negligent in causing the accident? No, the accident would have happened whether you were in the car or not. However, if you're injured in a car accident, could the defendant say, well, you assumed the risk that you would be injured. You got in the car with someone who was drunk. You knew, or you should have known, that that posed an increased risk to your own safety, and you voluntarily chose to undertake that risk. In a traditional common law contributory negligence state, you would be barred from recovery under the doctrine of assumption of the risk. In a comparative negligence jurisdiction, the defense is still good, assumption of the risk. However, it will probably be an offset. They'll probably divide out the liability between the plaintiff and defendant, so it will be a subtraction against the total damages. Again, though, assumption of the risk is a defense in all jurisdictions. One more time on remedies. The remedy, if the plaintiff is successful in a negligence lawsuit, the remedy will be compensatory damages. The plaintiff will normally not be eligible to get punitive damages. The idea in the lawsuits with negligence is to compensate the victim, but because it does not involve intentional or reckless conduct, we don't punish the defendant. So normally the plaintiff will not get punitive damages.